Hello there, and welcome to today's session on duress and undue influence as a topic in vitiating factors in the law of contract. So the courts have always been keen on preserving the principle of freedom to contract, and this is because an individual is free, if they are of sound mind and of the age of majority, to enter into any agreement which the courts would have to respect. And this means that consent is at the heart of every contract, and coercion, being the opposite of consent, then vitiates the contract and renders such a contract voidable. So let's look at the question of duress as well as undue influence and see exactly how coercion is used or pressure in order to secure an agreement from another party by a party who might. Traditionally, coercion has given rise to two forms of action. It's either at common law, which then the action would arise for duress, or in equity, where there would be a claim for undue influence. Duress is a common law area which has been associated with intimidation, where pressure is exerted in order to induce a party to enter into an agreement or to enter into an act which they would otherwise not do. Whereas with undue influence, this is really under equity. We're looking at different categories of parties who are in a dominant position, inducing another party to agree to do something based on the type of relationship they have or based on the type of pressure which they would exert on the other party. So the two forms. So having mentioned that with duress, there's a question of consent being vitiated due to coercion or pressure and actually a threat, the courts are very interested in knowing the nature of this threat. And in various cases, they've looked at some of the attempts that people have made to use this defense of duress. For example, in the case of R versus Singh, this is a 1973 case, the Court of Appeal held that a threat to merely expose the defendant's adultery would not be sufficient grounds to plead duress. And also, in the case of the DPP for Northern Ireland versus Lynch, 1975, Lord Simon stated that the law would also not regard threats to a person's property as sufficient basis for this defense of duress. So in that case, what exactly? In order to have a good understanding of what this threat must be in order to qualify to use the ground of duress, we see a number of cases where the courts have laid down rules. But the general understanding is that the defense of duress must be based on threats to kill or to do serious bodily harm. If the threats are less terrible than that, then they can only be used as mitigation. The threat itself must be immediate or imminent in the sense that it is operating on the accused at the time that the crime was being committed. If a person under duress is able to resort to the protection of the law, he is expected to do so. And when the threat has been withdrawn or becomes ineffective, the person must desist from committing the crime. The question of whether a person who wants to use this ground of duress, whether that person could reasonably have been expected to extricate himself or herself and sought the protection of the law, having a safe avenue of escape, is cardinal in this issue of duress and the threat itself. In the case of R versus Hudson and Taylor, which is a 1971 case, two teenage girls who committed perjury during a trial of a gang member stated that they did so because the gangster was waiting for them in the public gallery during trial and that he had threatened that when they come out, he will deal with them in the streets. The defendants were convicted of perjury because the trial judge's opinion was that the defense of duress could not be available because the threat So, having seen that the courts would want the threat to be imminent, to be immediate, and directly linked to the offense committed, the courts then went ahead in the 1980s, specifically 1982, in the case of R versus Graham, in order to establish a test for duress. That is because of defendants who kept on trying to use this ground and the courts rejecting their reasoning. In the case of R versus Graham, the facts were that Mr. and Mrs. Graham lived in a flat, but Mr. Graham happened also to be a homosexual who had a lover, a Mr. King. Mr. King was a bully, very violent, who actually forced himself to live in the same apartment as the Grahams. And there he continued with his violence to a point. The facts of the case of R versus Graham are very important to giving us a basis to understand this test which the courts finally set in order to approve the ground of duress. So Mr. King, who happened to be living there and had a very violent personality, kept on stabbing Mrs. Graham, attacking her until she decided to leave and go to her mother's house. And whilst she was there, Mr. King was still not satisfied and persuaded Mr. Graham to actually present a story that he was unwell and that he needed her to come home and attend to him. So this is the story which was presented, and Mrs. Graham left her mother's house to go back to her matrimonial home, only to be attacked by Mr. King, who took a wire and decided to strangle. Further, as Mr. King strangled Mrs. Graham, he asked Mr. Graham to also assist him to hold the wire around her neck and pull it on the other side so that they could completely strangle her to death, which they did. And finally, King also asked Mr. Graham to help him dispose of the body. When the matter appeared and King was charged, he pleaded guilty and he was sentenced for murder. However, Mr. Graham raised the defense of duress, saying that he was also intoxicated. The trial judge directed that they apply a test to decide whether such threats in fact qualify to overbear or overwhelm the will and consent of the defendant and the grounds for that duress. So what happened now was that the ruling was that the defendant's will to resist the commission of this crime was not, in fact, eroded by the voluntary consumption of drugs and drink and so on. And his appeal failed. What the court said was that they would lay down a two-step test. And this is important. The first point to remember was the courts would ask themselves, was the defendant, or may he have been compelled to act in the manner that he did, because as a result of reasonably believing that King would actually kill him if he could not do that. That is the subjective test. Secondly, the courts asked themselves in this case that if a sober person of reasonable firmness sharing the same characteristics. The second point to remember in this two-step test was that the courts asked themselves if a sober person of reasonable firmness sharing the same characteristics of the defendant would have acted in the same way. And of course, this reasonable man test is one which is always used by the courts. Reasonable meaning somebody of average strength, average intelligence, would they have acted in the same way under the same circumstances? Well, this is something which is now the standard in terms of using this ground of duress, that firstly, would you have had an opportunity to escape? And was the threat such a life-threatening one? Secondly, would a reasonable man, somebody of average fortitude, average type of intelligence. Subsequent cases such as R versus Hegarty in 1994, R versus Home in the same year in the criminal courts received matters in which psychiatric evidence was being used in order to show that someone who is mentally challenged could also, feel vulnerable and unable to defend themselves, and therefore the ground of duress ought to be applicable to them as well. The courts of appeal refused to admit this type of evidence in both cases because of the argument that a reasonable person should be endowed with a characteristic to be able to, on reflex, escape from a threat, and also, if their life was being threatened, to be able to have it as a life-threatening incident and not a mere... In the case of R versus Boehm, 1996, also a criminal case, the question of mental illness also arose, and in this case we're looking at mental defectiveness, mental impairment, and a low IQ being factors which could probably stand in this ground of duress, meaning that such a person would be able to use the ground of duress. But the courts again challenged this and stated that a person who has less IQ or even a mental illness is not less courageous when they're faced with a life-threatening situation, and they're also not less able to withstand threats and pressure than any ordinary person. So in this case of R versus Boehm, the courts now laid down other principles which they wanted from now on defendants to be. In the case of R versus Boehm, the judge held that factors such as age, gender, and the physical health of the defendant might be relevant characteristics in trying to determine whether indeed that defendant was of reasonable firmness or not. But he said that the mere fact that an individual, an accused person, is more vulnerable or timid or susceptible to threats than an ordinary person did not make it legitimate for that person to commit the offense that they did. Further, that the jury would want to look at the type of pressure and the ability to escape from that type of pressure, and they would only accept it in the event that someone, if it's a woman, maybe was pregnant, or someone suffering a serious physical disability, or somebody with a mental illness. Other principles set out in the case of R versus Boehm were that the courts would not accept certain other characteristics which the defendants might want to rely on, such as stating that maybe they're a homosexual or stating that they were intoxicated, because intoxication in itself is considered to be a self-imposed type of abuse, either alcohol, drugs, or other substance-related abuse that would also not be considered. But really, what the courts would want to know is whether that person of average intelligence, average strength, was susceptible to the type of pressure and threats, and whether the threat itself was so immediate, life-threatening to the life of the accused person, who then went on to commit this heinous act, such as, as it was. Other areas which would not qualify to use the defense of duress are, for example, in the case of R versus Sharp, where someone joined a criminal gang which was committing robberies in the area, and when he wanted to pull out, one of the gang members threatened to kill him if he did not continue with the plan. In that case, again, the defense of duress was not available, because the court stated that a person who joins a criminal gang knows that the purpose of that gang is to go and commit crimes. So that is one instance where the defense of duress is not available. And now we come to the principle of economic duress, specifically divided into duress of the goods and economic, which is commercial duress. Duress of the goods involves a situation where one party unlawfully seizes, detains, and destroys goods of a weaker party in order to compel that weaker party to sign a contract for a legally insufficient consideration. So the landmark case is the case of Occidental Worldwide Investment Corp versus Skibbs, which is also cited as the Sibian and the Sibotre 1976 case. In this case, what happened, the ruling was that if a weaker party is compelled to sign a contract for a legally insufficient consideration under imminent economic duress, on the other hand, apart from duress of the goods, is a more legal development in the commercial space. And this involves a situation where a threat is being made by a dominant party to prejudice the innocent party's economic interests. And that dominant party's threat is made to procure a contract with the innocent party. So if you look at the case of the North Ocean Shipping Company versus Hyundai, which is also known as the Atlantic Baron, you will see that court held that where a contract is being used to somehow oppress or coerce another party to enter into an agreement where they are going to lose substantially, that also is known as economic duress. The other case is Pao On versus Lao Yi Long, 1980. Again, this was a commercial. In the case of Pao On versus Lao Yi Long, 1980, the same one which I earlier cited, Lord Scarman pointed out a number of factors which need to be asked by the court when trying to determine whether indeed economic duress has occurred. And here he set out a few questions that must be asked to the innocent party, and stated that we must find out whether the innocent party who was coerced, firstly, had an alternative course of action available to them in that commercial transaction. Secondly, did the innocent party protest in any form and at any stage of the transaction? Thirdly, did the innocent party who is coerced have an opportunity to receive independent legal advice? And finally, what steps did the innocent... In the case of Pao On versus Lao Yi Long, 1980, the same one which I earlier cited, Lord Scarman pointed out a number of factors which need to be asked by the court when trying to determine whether indeed economic duress has occurred. And here he set out a few questions that must be asked to the innocent party, and stated that we must find out whether the innocent party who was coerced, firstly, had an alternative course of action available to them in that commercial transaction. Secondly, did the innocent party protest in any form and at any stage of the transaction? Thirdly, did the innocent party who is coerced have an opportunity to receive independent legal advice? And finally, what steps did the innocent... Finally, the courts asked themselves whether the innocent party coerced did take steps to avoid the contract. So you can see that the commercial pressure which can render a contract voidable is where it has been procured by a stronger party against a weaker party. However, even in that situation where coercion is being cited, there's need for all those factors to be taken into account for the ground of economic duress to in fact stand. Other cases of interest are the case of Atlas Express versus CAFCO, 1989, very instructive. Also Universe Tank Ships of Monrovia versus International Transport Workers, also known as the Universal Sentinel. And you can also, I think as well as the Hyundai